File a complaint with OSHA. That's the first step in the process. So it's an administrative process is what they call it. So that filing of the complaint is the first thing, and that doesn't cost you anything. Whereas if you file a lawsuit in federal or state court, there's definitely filing fees associated with that. OSHA doesn't require that at the first step in the process. So you can put in with OSHA a complaint, and then the OSHA investigator, what they do initially is investigate that complaint. So they'll talk to you, they'll do an interview with you. If you have a lawyer, Danny and I would be with you during that interview process. They also talk to your coworkers. They gather the evidence. OSHA does this, and then they issue findings in your case. So they either say that your complaint, which you've put in with them, meets all the requirements under this particular law, meaning that it's dealing with safety, the railroad has retaliated, and then they issue what they call findings, which will say in an instance where you're wanting your job back. That's something that OSHA can do. They can put you back to work. They can get your back wages. They can also do what they call front pay. So if it's such a bad environment that OSHA doesn't think that you should be back at the railroad, you can ask for them to issue front pay, which is front wages. But if OSHA and the investigative process doesn't find that there's a violation, that's not where your claim could end. You could also appeal that to an administrative law judge that also can hear the case and hear evidence, and you would have a sort of trial on the merits of your claim. And if OSHA, many administrative offices are sometimes very, very busy and backed up, so they have provisions that protect you. So if they are not able to get to your claim within 210 days, then you're able to what they call opt out, and you can move your case and file it in federal court.